Hello and welcome to this seminar on doing business in Sweden. This is a multi-part series looking at various legal issues when doing business in Sweden. Today I'll be focusing on director liability. My name is Barney Feynman and I'm a lawyer with Prima Advokatbyrå in Borås. There are several forms of director liability under Swedish law. The one that I'll be focusing on today relates to what is referred to in English as impaired share capital. Now this segment will require some basic understanding of accounting terms, but nothing too difficult. In Sweden, companies must have a minimum share capital of at least 50,000 Swedish crowns. The share capital can be more, and very often companies choose to have more registered share capital. Now, registered share capital is not the same thing as money in the bank. Presumably, the company starts off with share capital being the same as money in the bank if the original share issuance was for cash, which is the most common form of payment. But after that initial payment of the share capital at the initial share subscription, things happen in the company. Hopefully things go well and the company makes money and there's more money in the bank than the original share capital. Occasionally things don't go so well and there's less money in the bank than originally was put in as share capital. So the first thing to keep in mind is that share capital is not the same thing as money in the bank. Share capital is simply the amount that the company has decided to commence operations with, and then that amount must be put in to the bank as the initial purchase at the initial share subscription. In Sweden, the minimum amount is 50,000, so I'll be using that amount as an example. The other accounting term that is important to be familiar with is shareholder equity. Shareholder equity can loosely be described as the company's assets minus the company's liabilities. So if we use, as an example, 50,000 crowns as the company's share capital. And if we say that the company now has assets worth 200,000 and liabilities equaling 150,000, well, then the shareholder equity would be 50,000 crowns. In other words, the same amount as shareholder capital. Now, if that shareholder equity should drop below 50% of shareholder capital and the board of directors has reason to suspect that shareholder equity has dropped below 50% of shareholder capital, then certain things have to be done. Let's use an example. Let's put some numbers on this. Let's assume the company has a registered share capital of 50,000 crowns. After several months or years of operation, the company now has assets equaling 200,000 crowns. The company has debts and obligations equal to 180,000 crowns. In that case, the company's shareholder equity is equal to 20,000 crowns. In other words, 200,000 minus 180,000. Now, we have to compare that shareholder equity to the registered share capital. Registered share capital, we said in our example, is 50,000 crowns. If we compare that to shareholder equity of 20,000, we can determine that shareholder equity is less than 50% of registered share capital. The registered share capital was 50,000. 50% of that is 25,000. Shareholder equity $20,000. So in this scenario, we've entered the red zone. In other words, we've entered the scenario or the situation when the board of directors must act. There are several concrete steps that must be taken, and they must be taken pretty quickly. The first step, they must prepare a control balance sheet. Well, hopefully everybody is familiar with the term balance sheet. It lists the company's assets, it lists the debts, and it also lists shareholder registered capital and shareholder equity. Now, a control balance sheet also consists of those elements, but there are certain favorable valuation principles that can be applied. But the control balance sheet must be prepared, and it must be prepared as soon as possible. The statute does not specify how quickly soon as possible is, and whether you have a few weeks or a few months will depend on the nature of the company. Larger companies with subsidiaries, especially business operations outside of Sweden, may be entitled to a little bit more time than a small, closely held company with relatively few assets, and all of them here in Sweden would be entitled to. So, as soon as the board of directors has reason to suspect that shareholder equity is below 50% of shareholder capital, then the board should immediately consult a lawyer or an accountant or somebody else with competence in this area for advice. The board will then prepare the control balance sheet, and you must present it to the company's auditor for review. The auditor will review it, and if the control balance sheet confirms the board's suspicion, and we now know that equity is below 50% of share capital, then the next step is to refer the matter to the shareholders. In other words, the board will call an extra shareholders meeting. This also must be done as soon as possible. You cannot wait. And you cannot pause this process, even if it's going to be vacation time in the summer or the holidays at the end of December. You must act quickly. When you assemble the extra shareholders meeting, the board presents the control balance sheet to the shareholders. The shareholders will then have a choice. They can decide that the business prospects are not good, and they can vote to wind up the company. It's referred to in Sweden as a liquidation, a voluntary liquidation. The other alternative for the shareholders, if they so choose, is to continue the business operation. They're free to do that, and there's no consequences attached to such a decision. If they decide to do so, well, then a clock starts to tick, and this clock will tick for 8 months from the date of the first shareholder meeting. And at the end of this 8-month period, the board must present a second control balance sheet to the shareholders at a second shareholder meeting. If that control balance sheet, in other words, control balance sheet number 2, shows that the shareholder equity is equal to 100% of shareholder capital, then we've resolved the problem, and the company continues to do business as previously. If the second control balance sheet does not show that shareholder equity is 100% of shareholder capital, then the board is obligated to apply to the court for liquidation proceedings. So there you have the steps that need to be taken. What starts the process is the board suspecting that shareholder equity has dipped below 50% of registered capital. Then the board has to spring into action. Step number 1, prepare a control balance sheet and do it as soon as possible. Step number 2, have the company's auditor review it. Step number 3, refer the matter to the shareholders at an extra shareholder meeting so that the shareholders could decide whether or not to keep going or not. Step number 4, if the shareholders have voted at the first meeting to continue operations, well, then you have 8 months to rectify the situation and restore shareholder capital so that equity is equal to shareholder capital. If you have not managed to do that, then the company must be put into liquidation. Here's the bad news for directors that fail to follow these steps. If you do not follow the steps, as I've previously described, then the directors are personally liable for those debts and obligations that arise after the point of your malfeasance or nonfeasance, was just a strange way of saying after the point where the directors missed a step. So the directors can become personally liable for company debts. It is those debts that arise after the directors have made a mistake. In other words, if the directors fail to prepare a control balance sheet within a short period of time after they had reason to suspect the impairment, well, as soon as they had reason to suspect and a reasonable time to prepare the control balance sheet, after that point, they are on the hook for new debts and obligations that the company incurs. On the other hand, if they manage to prepare the control balance sheet on time, but they were negligent in performing step number 2, in other words, they didn't send it to the auditor as quickly as possible, or they got it to the auditor on time, but they were negligent when it comes to step number 3. They failed to call a shareholders meeting as soon as possible. Well, then they would be obligated for company debts and obligations after that point. So those are the steps that need to be taken after the company's directors have reason to believe that shareholder equity is less than 50% of shareholder capital. In another segment of this series, I'll go into the various ways a company can remedy the situation. But I just want to close this segment by emphasizing to all persons considering becoming directors of a Swedish company that these rules are rules you do need to understand. And this means that you do have to closely follow the finances and the financial condition of the company in which you're serving as a director. If you're not closely following the company's financial condition, there's a risk that the company may end up being in a situation where the control balance sheet needs to be prepared, but you're unaware of that. And that could very well lead to a personal liability for company debts and obligations. Thank you, and I hope you found this segment informative. Bye-bye.